We have built our firm around one idea: to lead our clients from where they are to where they want to be. But the ability to deliver the leadership and service our clients deserve doesn't happen by chance. It's a product of who we are. We are engaged, diverse, and innovative thinkers who go above and beyond what is expected because we know our efforts will carry us to achievements others never thought possible. We are unafraid to take the necessary risks that lead to new successes. We embrace change because we know sound principles will guide us through new opportunities. We are committed to empowering our people, our clients, and our communities to become every part of what they aspire to be. We are persistent on our journey forward. It is our openness to collaboration, our desire to achieve better, our character, our vision, and most of all, our people that make us who we are. That's the HB difference. We are Husch Blackwell.
Hello, everyone. This is Alex Rushing. I'm an attorney in Husch Blackwell's higher education group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today. But if a fuller answer is needed or we run out of time, we'll be sure to answer your question via email after the program. We truly appreciate audience participation and encourage you to submit questions throughout the program. A PDF of the presentation is available in the resources folder. This program has been approved for legal education credit and HR credits. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your institutional needs. This program was actually born out of those responses over the course of several webinars, so please be sure to keep your feedback coming. That is all for the housekeeping items, so let's get started with our program. Joining me today are my amazing colleagues, Jason Montgomery and AJ James. A former NCAA investigator, Jason represents colleges and universities nationwide in enforcement, eligibility, and compliance matters. In addition to his private practice, Jason has served in multiple regulatory positions at the NCAA, including as an investigator and an academic and membership affairs staff member, responsible for waivers and rule interpretations. AJ has represented universities and colleges in a wide variety of complex litigation matters, including Title IX, Title VI, Title VII, state and federal employment disputes, Section 1983 claims, and class action claims. AJ frequently advises collegiate institutions on various athletic-related matters, including NCAA compliance and risk management. Here on your screen, you're going to see the list of topics that we're going to cover during the course of today's webinar. I'm going to start by talking about student athlete and peer investigations, so investigations involving student athletes and their fellow students on campus. Then AJ will take over talking about student athlete and coach investigations or other institutional employees involved in investigations involving student athletes. And finally, Jason will conclude with NCAA investigations. So before we get started, I was a third grade teacher, and so I always like to get to know who my audience is before we try and figure out some of these issues together during the course of the next hour. So we're going to start with a poll question. On average, how many investigations does your institution have involving student athletes? We have them approximately 0 to 10 times per year. We have them approximately 11 to 20 times per year, 20 plus times per year, or you don't know. And we'll wait for those responses to come in. I see the responses slowly trickling in, but still moving, so I'll give folks another couple seconds. Okay, we've officially stopped moving, so we can share our results. So the vast majority of you are in that first category of 0 to 10 times per year, 65% almost, with the next most common being I don't know, and then followed by 11 to 20 times per year, and then about 2.5% of you at that 20 plus times per year. So that's really good benchmarking for us to know where everybody sort of stands on this issue. Okay, let's ask another poll question. What is your role in investigating issues involving student athletes? Are you predominantly in the Title IX investigation space? You investigate student athletes related to student code of conduct investigations? You deal with student athlete investigations involving athletics code or team rule violations, or you don't fit in any of those first three categories, you're in the other side of things? We'll give a few moments for those responses. I see those trickling in, but we're still moving, so I'll give folks an opportunity. Okay, let's see these results. Again, our first category is the dominant one. Most of you fit in that Title IX investigation space at almost 60%. The rest of you are in that other category at 28%, and then about 6.8% in the athletic code or team violation rule issue, and then finally 6.4% at the student code of conduct investigation. So that's great. That's really helpful for us to see where everybody on this call fits in. I did not think it would be so dominant in the Title IX space, but that being my favorite area of the law, I am certainly happy to hear that. So I'm going to get started with my portion of the presentation discussing issues related to student athlete investigations involving their peers. Like I said, this could be issues involving alcohol and other drugs, hazing, criminal charges or conviction policies, and like I said, my favorite, Title IX. I want to make sure to note at the beginning that we're exploring issues related to student athletes and investigations involving them as both respondents and complainants. These situations can also involve both parties being student athletes, one party being a student athlete, or an entire team involved in some capacity in an investigation as witnesses, support persons, etc. So as we go through the next slides and some case studies, don't focus on a student athlete being the respondent, because we all know from working in this space, student athletes come up in situations all across our investigations, and their role changes investigation to investigation. Okay, now let's get into it. Here are some unique factors that may not be so unique that all of you have encountered in your experiences involving investigations related to student athletes. We highlight these because these are the areas that from a compliance perspective, we see come up over and over and over again in our practice, advising clients on these issues. But we also see it come up in the case law as well. So we will break down each of these over the course of the next couple slides. But so you have a roadmap of where we're headed, we'll focus on internal and external pressures, conflicts of interest, bias and prejudice, maintaining confidentiality, and most importantly, maintaining consistency, that final category. So let's start with the first one, the internal and external pressures. These pressures may be perceived or felt by you as the investigator or adjudicator on these matters, rather than explicitly occurring, or they may be actual pressures you're receiving. This can look a lot of different ways. It can be feeling the pressure to prioritize a Title IX sexual harassment investigation over others because you know the season for the complainant is about to begin and you want this situation to be behind that student athlete. It can be a coach sending frequent requests for a status report on how an academic dishonesty charge is processing because the conference championship is around the corner. The internal pressure that I'm talking about can come from institutional stakeholders like teammates, coaches, administrators, athletic department members, you name it. The external pressures can come from all sorts of individuals, everything from parents to boosters, the media, OCR, other government agencies, even the court system in the form of litigation or subpoenas, things like that. Going hand in hand with the prior slide about internal and external pressures is this slide about conflicts of interest, bias, and prejudice. First and foremost, having a strong conflict of interest policy is critical to avoid this issue impacting an investigation involving a student athlete and receiving proper training on how to appropriately identify conflicts, bias, prejudice in your process. Having a policy is great, but not knowing how to properly implement it is where we see a lot of institutions run into issues. Make sure you're reviewing this policy at least annually and that all the stakeholders who are part of your process for the investigation and adjudication of these issues involving student athletes, or really all students, understand not just what the policy says, but how it works in practice. So you're probably asking yourself, what exactly do I mean by that? What I mean is that it's great to train annually on the policy language, but think about going through scenarios of identifying conflicts of interest and when something is an actual conflict and the investigator must be removed versus a situation where optically you may choose to remove someone from an investigation, but that it's not really a conflict of interest. Let's go through an example on the next slide of exactly what I mean by that. So take a look at the screen and you'll see a very standard Title IX sexual harassment conflict of interest policy. For those of you who like to minimize during our webcast, I would encourage you to maximize your screen, and I'll read it out loud in case you want to keep it minimized and just listen to my beautiful voice repeating it. But the Title IX coordinator, investigator, hearing officer, administrative officer, appeals officer, and informal resolution facilitator will be free of any material conflicts of interest or material bias. Any party who believes one or more of these officials has a material conflict of interest or material bias must raise the concern promptly so that the institution may evaluate the concern and find a substitute if appropriate. The failure of a party to timely raise a concern of conflict of interest or bias may result in a waiver of the issue for purposes of an appeal or otherwise. So here's our scenario that we're going to go through. A female diving team member accuses a male swimming team member of non-consensual sexual intercourse under your sexual harassment Title IX policy. You are the assigned investigator and you identify as female. This brings us to our third poll question of the day. Is this a conflict of interest under your policy, the template policy we had on the other slide? I'll give a few moments for those of you to answer. Is it yes, no, I don't know, or my favorite answer, I'm an attorney, so I always say it depends? We'll wait for those responses to trickle in. Okay, I see the responses have stopped, so I'm going to move to the next slide. So we have 1.8% that said yes, 70.5% said no, 7.7% said I don't know, and 20% of you love my humor and say I'm an attorney, so I always say it depends. Here, I think the best answer is no. This is not a conflict of interest because you as the investigator identify as female. A conflict of interest is when an individual has a material connection, that's what we know from the language of the text, to the dispute or the parties involved, such that a reasonable person would question the individual's ability to be impartial. Here, you being female is not a material connection to the dispute or parties, nor would this fact alone likely cause a reasonable person to question your ability to be impartial. A conflict of interest can be based on prior existing relationships, financial interest, professional interest, prior involvement, or the nature of your position, but none of those appear at play here. So you as an institution can choose in this situation to have a male investigator or a female investigator, but I don't recommend you do that type of swapping solely based on things like race, sexual orientation, etc. of the investigators. It should be based on something more than that. Maintaining confidentiality is the next unique, not so unique factor that comes up in student-athlete investigations involving their peers. Because so many of these situations involve multiple members of one team or even multiple teams, maintaining confidentiality is a real challenge in these investigations. But there are some things you can do to try and keep the investigation as confidential as possible on your end, and to create what I like to call a culture of confidentiality among the parties and witnesses involved. First, when you're communicating on potential issues outside of your office's jurisdiction to other institutional stakeholders, only do that on an as-needed basis and identify that need in advance of sending an email, a text, a team message, etc. What I mean by that is if you have a situation where you're investigating, let's say, a student-athlete's complaint that their laptop was stolen from the library, and you discover that the reason the student-athlete was studying in the library in the first place was because their roommate was having an underage drinking party, you certainly need to communicate that to someone outside of your office and maintain any reporting obligations if they apply. Here, most likely to the Dean of Students or someone in Student Affairs or Housing. But before you do so, outline all the areas that you need to identify potential reports and the specific individuals you need them reporting to. Then make the report. The next step of maintaining confidentiality is the importance of updating the parties. Here, it's critical not just to discuss this issue at the beginning of an investigation, but also throughout the investigation. But you want to be careful that you're doing this equally to both parties and not just reminding one party over the other. Even if it's unintentional, this can be a big issue, and we'll touch on that in the next couple slides related to consistency. But as it relates to confidentiality, the other piece, and you'll see it on your slide, is the issue of anonymity. And this is especially important at the beginning of investigations, at least I found in my experience doing these sorts of investigations, when you're doing intakes and also when you're meeting with the witnesses for the first time. In investigations involving student athletes and their peers, we all know how small the athletic community is, even if we're at a big school, and even smaller on each team. So making sure that the parties and also the witnesses know the information you're discussing may end up in a report or discussed with other parties, et cetera, is really important to set that expectation up front. The final piece that you'll see on your slide is the anti-retaliation policy. Sometimes we forget about our anti-retaliation policy and how much it goes hand in hand with all our investigations, but especially with those involving student athletes and their peers. Again, keeping in mind that as you're building this culture of confidentiality in your investigations, you don't want the parties or witnesses to think they have a gag order in place. So having policy language that strikes that right balance of emphasizing the importance of confidentiality, but also addresses the manner in which the parties and witnesses communicate about or discuss the particular case may constitute a separate violation or retaliation and may be subject to discipline, is important to set that expectation up front and throughout. So I flagged this throughout some of the other slides, but maintaining consistency is the most critical thing, in my opinion, as it relates to investigations involving student athletes. But it's also the one where we see the most amount of complaints internally at institutions, externally with OCR and the media and litigation. So I say this, but it's obviously a lot easier said than done to be consistent. Here are some areas that I think you all may want to double check as you're working through your investigations, making sure that you're being consistent involving student athletes and those involving other students generally. I want to focus just on a couple of them on your screen. So the first one is related to the initial notices and support resources, making sure that you're not providing, not only just providing substantively the appropriate notices and resources, but that you're doing it timely. Timeliness is really important in these investigations, as you all know. The next is interim measures, and this will be very policy dependent and institution and team dependent. I flagged this because we had so many folks that said that Title IX was the area of their expertise and where they see this issue come up the most. So I want to flag this especially for all of you. Many institutions are revisiting their practices of removing students accused of sexual assault or sexual harassment from athletics in light of the new Title IX regulations. The regulations and commentary put an emphasis on protective measures not being what they say unreasonably burdensome on the respondent, and that determinations of what constitutes an unreasonable burden are fact-specific, meaning each protective measure should be considered under the particular circumstances involved. The U.S. Department of Education does not foreclose the option of removing a student from athletics where circumstances require it, but the department provides examples of alternatives that may be more appropriate, like campus safety escort services, schedule changes, online classes, resident options. The department even goes so far as to provide an example where the complainant and respondent are on the same team and suggests that a no contact order may be appropriate in those circumstances. Unfortunately, without providing any further explanation on how logistically that actually plays out in practice. So let's see how it plays out in real life and in the form of litigation. In this case on your screen, you'll see that 2 football players called the university police to report that a fellow athlete raped another student in her on-campus apartment. The alleged victim is referred throughout the case as Jane Doe 1, so that's how we'll refer to her as well. Jane Doe 1 refused to file a complaint, but the university noted the report in its tracking system. After the incident involving Jane Doe 1, a different female student, Ross, reported to the university that she'd been raped by the same alleged perpetrator, the same student athlete as Jane Doe 1 was. In the course of the university's investigation into Ross's allegations, it was discovered that another Jane Doe, besides Jane Doe 1, alleged that the same student athlete had attempted to rape her. Ross filed a federal lawsuit in the Northern District of Oklahoma against the university, claiming that the university failed to protect her from the student athlete and was deliberately indifferent to rape accusations against her as a student in violation of Title IX and Oklahoma state law. So this brings us to our next poll question. How do you think this case ended up? The first option is that the university settled out of court. The second option is that the court finds the original incident with Jane Doe 1 did not place the institution on notice that the student athlete posed a substantial risk of assaulting other students. The third option, the court finds the original incident with Jane Doe 1 did place the institution on notice that the student athlete posed a substantial risk of assaulting the other student. Or the final option, none of the above. I still see answers trickling in, so we'll wait a few seconds. Okay, I've seen that the responses have slowed down, so I will move on to the next slide for our results. So the most popular response is the 40%, the third option, that the court finds the original incident with Jane Doe 1 did place the institution on notice. The second most common response was the second option, that the court finds the original institution did not place the institution on notice. 23% of you believe that the university settled out of court, and then the final option is that none of the above. In this instance, the court found that the university police's investigation into the incident involving Jane Doe 1 did not place the university on notice that the student athlete posed a substantial risk. So the answer that is correct is actually B in the above situation. The court even went on to describe how the burden would be too great to require a university to investigate, discover evidence, and take into account an action to prevent future crimes, all without the cooperation of Jane Doe 1. So because Jane Doe 1 was unwilling to move forward with an investigation, and therefore the respondent wasn't on notice, there was not an obligation from the university in that original Jane Doe 1 situation. Let's go through another case study to see how this plays out in a different jurisdiction. This case involves a student who was sexually assaulted by 3 other student athletes. The student informed the university police the same night, and the investigation began immediately. A preliminary report was created within 48 hours of the assault. A full investigation report was available approximately 3 months after the assault, and the disciplinary hearings took place approximately 1 year after the assault and resulted in no sanctions to the student athletes. Based on these facts, you can probably see what we've talked about in our unique factors and things to think about earlier, what went wrong here. Here, this was a timing issue. The court found that the investigation and immediate response were not improper, but the court noted that waiting nearly a year after the assault and approximately 8 months after the completion of the initial investigation was considered deliberately indifferent under Title IX analysis. The court rejected arguments that the university's own hearing process was delayed pending the outcome of criminal proceedings against the student athletes. The 11th Circuit doesn't get into this issue in great detail, but again, we can guess that the parties were not being updated during that 3 month, or at least not being updated very frequently during that 8-month delay from the initial investigation to the hearing. And that may have contributed to the frustration of the parties and could have even motivated litigation to begin with. Also, it's not discussed in the case, but this made me think of reminding you all to ensure your policies discuss this concept of criminal investigations and their impact on your particular process. So that brings us to our final slide in this section, best practices as it relates to investigations involving student athletes and their peers. Preparation is critical in all investigations, but especially those involving student athletes, whether that relates to preparation on scheduling interviews, preparation on appropriate investigators to assign to a given matter, or preparation of the policies that may come up that are unique to student athlete complainants and respondents or witnesses that you may want to know the answer to in advance of meeting with those individuals. Building rapport is another best practice I recommend, and one that can really be overlooked related to student athletes, especially if you're doing a climate assessment or an interview of a large team and interviewing all of the athletes. Don't fall into that trap. Think about how to build rapport with each individual student athlete you interview. And it may not be about sports, so you got to think creatively. By that, I mean, if you're investigating a student athlete about a complaint they filed about a fellow softball player, you might not want to ask how the softball season's going. So think it through in advance and how you can talk about something else to build rapport besides sports. Because in some instances involving student athletes, that may be the very last thing they want to talk about since they're talking about something they're complaining about related to their athletic team. Listening obviously is one that applies to all investigations, but here with student athletes, I want to flag the importance of verbal and nonverbal cues. In my experience, at least, student athletes can have some of the best poker faces, but there may be other nonverbal cues like body language to pay attention to, like shifting in their chair, not maintaining eye contact, asking for questions to be repeated multiple times, or identical answers among several witnesses in a row. All of these may be great cues for you on how to move forward with the next step in your investigation. Consistency, consistency, consistency. This is so important, I have to say it 3 times, which also happens to be my former basketball number, so that's how much you know I value it. Being consistent among every part of your investigation and among your investigations with student athletes and non-student athletes is so, so important. So we have to make sure we emphasize it. Also, be aware of compliance concerns. This is the next one. By this, I mean consider how many issues seem part of the team culture or commonplace among athletes and how that may still be a policy violation and may absolutely warrant follow-up and investigation. An example of this is something that for those of you, and I see a couple attendees who attended our informal resolution training this past week that we did on Tuesday, you all may remember this from one of my hypotheticals, and it may be something that's part of team culture that all student athletes tap each other on their behind after a good play or at practice. But just because something's part of the team culture doesn't mean that it's not something that raises a compliance concern. So always be aware of that and proceed appropriately with your policies and practices. The next one is to track, monitor, and reevaluate your situations as an institution and that may arise involving student athletes, and consider audits, surveys, and other assessments, because that may have seemed like an isolated incident to one student who's reporting it or who's disclosing it in a witness interview. Or in one instance, it may be a larger issue among the team, a group of teams, or an entire athletics department. So always keep track of those issues. Finally, my last, but certainly not least best practice is to be cognizant of your timing. We saw that play out in the Williams case from the 11th Circuit, where the university processed everything right on time, but then delayed because of a criminal investigation. Watch out for those type of errors. But even outside of a criminal investigation delay, be cognizant of your own timing of investigations and how long things are taking. And the best thing to do is to communicate with individuals that are involved in advance of any delay. This will not only be better for you and the institution if it gets to OCR or litigation, if you require us to put a nice timeline together of what's happened, but it also sets a great precedent in your office of timely investigations and responsiveness, which will encourage participation and cooperation from student athletes and from non-student athletes alike. So with that, I will turn it over to my colleague, AJ James, to talk about student athlete and coach-related or other institutional employee investigations. AJ?
Thanks, Alex. Great presentation by Alex. I'm going to take the whole presentation in a little bit of a different direction here and talk about investigations that involve student athletes and coaches. And a lot of times that is going to bear as well on other institutional employees and kind of how they interact with student athletes. A little bit about myself first. My name's AJ James. I was a student athlete myself. I played baseball at Appalachian State, what seems like a lifetime ago. So this is a little bit of a topic that I'm proud to say I never had any with as a student athlete, but something that we do run into with some degree of regularity in our practice. So with that, I'm going to go ahead and kind of mirror what Alex talked about earlier and give you guys some unique factors that you might run into involving student athlete investigations with coaches, some things that may be different from typical investigations or from investigations involving student athletes and their peers. The first consideration that we have to think about is the power dynamic between coaches and players. And what we mean by that is, most of the time we have a situation where a coach is in a position of power over a player to the extent that the coach controls things like their scholarship amounts, their playing time, in a lot of cases, their physical experience playing the sport. We see issues a lot of times where athletes are somewhat reluctant or hesitant to oppose a coach or report things that might implicate a coach or require a coach to be a part of an investigation out of fear of having their scholarships reduced, having conditioning at practice or before games, things like that, reductions in their playing time, and also just general problems they run into with the team, especially when teammates are involved. So we touched on that a little bit, but the second issue we have here is reluctant reporters. And this really comes in multiple senses. So we have, for all the reasons we just discussed, some issues with student athletes being reluctant to report incidents of misconduct or anything else they might otherwise report to the appropriate channels within the university. We also have issues with the coaches themselves being reluctant reporters, and this could be for a number of reasons, including creating issues on the team, potentially having a student athlete not be available for participation. Could also include negative PR for the program, depending on what they're trying to do recruiting-wise. If the situation could result in a lot of media attention, especially for larger programs. Thinking of, we always think of the Division I football and basketball programs in this sense, and there's been a couple relatively highly publicized situations over the past couple months that we could all point to look at there. Another issue that we run into with reluctant reporters is, and occasionally, the actual victims themselves. If there's a situation where we have a third party, whether it be another student, a peer, an athletic trainer, something along those lines, they may be reluctant to report incidents involving a coach or involving a student athlete and a coach out of fear that the university either will not listen to them for whatever reason, or that the university might want to protect high-profile coaches or athletes. Those fears are obviously, by and large, unfounded, but they do exist among people who might otherwise report. Third issue that we run into a lot of times with these types of investigations is just general cooperation. So for the same reasons that somebody might be reluctant to report an incident, we run into reluctant participants in the investigations themselves. A lot of times we have coaches that don't want to avail themselves to investigators for meetings or to search for documents, things like that that we might be looking for that might aid an investigation for a variety of reasons. A lot of times we see the coaches being concerned about schedules or competitions, practices that limit their availability. We also, have issues with the coaches not wanting to throw their players under the bus, not wanting to, be as complete or as open, disclosing all the information that the investigator might be seeking, because they think that it might result in adverse consequences for the team or for the player themselves. Similarly, we run into issues with the players themselves, being afraid of consequences they might receive from the coaches. Again, most of the time unfounded, but those fears do exist. Another issue that we might run into with the players cooperating with the investigation involves their teammates. A lot of these investigations involve multiple members of the same team, and players who may not be named as a respondent or as a complainant in an investigation might be hesitant to say something that they think is going to be held against their teammate or held against their coach that they think might interfere with their team, with their own personal athletic experience, or that's going to create problems for some of their friends. And that ties into our very last important factor to think about here, which is team dynamics. Again, a lot of times these players don't want to do things that are going to create an issue for their program. They don't want to do things that are going to create distraction during the sports season. They don't want to take time away from practice, from competition, from travel, whatever the case might be, which is an important consideration when you think about the time constraints that a lot of our student athletes are under. We have athletes who a lot of times are waking up significantly earlier than most students to work out or practice, whatever the case might be, going to class, traveling, and then obviously taking part in the actual athletic events themselves. So a lot of times they'll try to skirt these issues, or they might not be as complete and truthful during an investigation as we might otherwise like. So with that, I'm going to talk about a couple different cases here that have some unique takeaways involving coaches and student athletes, hopefully some things that we can all learn from, things that were done correctly, that could have been done better, or that didn't occur at all for one reason or another, and how that affected the institution from a legal perspective. So the first case we have is DeSecco versus University of South Carolina. And factually, in this case, it's a little complex, so I'm going to spend a little bit of time unpacking it and walking us through what the factual backdrop was, so we can see just how the court came down on this issue. So in this case, we had a plaintiff who was a female student athlete and made complaints against her head coach and assistant coach. This is a very unique situation in that the head coach was a female that was married to a male assistant coach, both in the same program. So in this case, we had a plaintiff had some struggles during her freshman year, as a lot of student athletes do coming into a new environment and playing in a sports team, especially fall sports where we have an athlete that's coming into a new environment and is in the middle of competition right away. So in this case, she had some struggles during her freshman year, and then in the middle of that first season during the fall, experienced a reported incident of sexual harassment by the male coach. What had happened was the coach asked her to step into an office near their locker room after a game one day, shut the door behind them, locked the door, and then proceeded to have a conversation with the player about her playing time, among other things, and eventually put his hand on the plaintiff's leg inappropriately. The plaintiff then discussed this issue with her father, and the conclusion that her father came to was that the coaches would be responsible for reporting the incident as opposed to the plaintiff herself. And this is one of those incidents where we might see a reluctant reporter here for one reason or another, is afraid of how the coaches might react or what the consequences might be for the coach ultimately, and decides not to report the incident. Later on, after this individual incident, the player starts seeing some, what she would consider adverse events, reductions in playing time. Ultimately, there's a reduction in her scholarship amount, which she begins to appeal through the institutional process, but ultimately does not follow through on the appeal. Later, the plaintiff and her father sought a meeting with the athletic director to discuss their concerns. And the key emphasis to look at here in the slide is some concerns. That's how they described it to the athletic director, not any specific concern uniquely, especially not naming, for instance, this closed-door meeting that took place. The athletic director informs the player and her father that the policy requires them to first try to solve the issue with the coaches themselves, and then talk to the sports team's administrator, here a member of the athletic department that's underneath the athletic director. Plaintiff obviously has already discussed some of these problems with coaches, so that step is kind of taken care of, and proceeds to meet with some of the administrators underneath the athletic director. During those meetings with the other administrators, the plaintiff continues to have issues with her coaches throughout the next year after these meetings take place, none of which, these meetings anyway, include specific mentions of individual incidents or potential misconduct, especially, we're kind of looking ahead here to that locker room incident. All the reports have to do with things about communication issues. So plaintiff eventually continues having these problems, and ultimately there's a sit-down meeting between higher-ranking members of the athletic department, the plaintiff, her father, and the two coaches. During the meeting, the father makes a comment when asked if something he had said was appropriate, of saying, quote, "How appropriate is it for your male coach to have a closed, locked-door meeting with a female athlete?" The exact language of that report is very important in this case. It's not reporting any specific incident. It's not reporting any, direct allegation of sexual misconduct or necessarily anything improper. It's asking about the appropriateness of a closed locked door meeting with a female. Now, obviously, the insinuation here is that the father's daughter experienced this incident, but there's no direct report being made. At that time, the head athletic administrator that's in the room asked the father if he would like to make a formal, and the father asked if he should before shifting topics to something more civil and ultimately ending with a somewhat productive meeting. After the meeting occurs, the father does not make any formal complaint, nor does the student athlete. The plaintiff ultimately withdraws from the university after the meeting and moves on. However, her involvement with the university and the situation as a whole is not over yet because she files a lawsuit. The plaintiff ultimately sues the university and the coaches themselves for Title IX violations and violations of her constitutional rights, among a couple other state law claims. Here's the important takeaways that the court ends up finding from this investigation, or from this litigation. The court found that actual report to the athletic department administrators did not indicate the allegations of sexual misconduct. There were no reports directly to the administrators at any time before that final meeting that in any way dealt upon any kind of misconduct or any other activity that would need to be investigated under the university's conduct policies, Title IX policies, anti-retaliation, what have you. The descriptions of the incidents were some concerns or communication concerns. Again, none of which are indicating this level of misconduct that would prompt us to conduct a more full-scale investigation. The athletic department itself discussed these incidents with plaintiff, but plaintiff never reported these specific sexual misconduct allegations. And that's an important takeaway here because it doesn't place the university on notice that there could be a potential problem that they need to either investigate or deal with. The second big takeaway here is that the individual coach's knowledge of the allegations and of the situation that could prompt an investigation under any kind of misconduct policy are not imputed upon the university for the purposes of Title IX. And that's mainly because the two coaches in this case were the alleged wrongdoers. Title IX case law indicates that when the official that has the ability to correct or act on a complaint is the alleged wrongdoer, that knowledge is not going to be imputed upon the university as a direct result. And this case really offers us, in retrospect, taking away a couple important items from it that tie into these unique factors and ultimately what we're going to discuss in a minute, some of the best practices to address those. The first one is that, as we've discussed, athletes might be hesitant to report misconduct by a coach, especially while they're actively playing under a coach. And this is for a variety of reasons. And here you kind of see a couple of them play out. The players are afraid that their playing time might be reduced, that their scholarships might be reduced, so they might receive some kind of other adverse treatment, or that they might be, perhaps outed to a teammate, something like that. Another unique instance that arises in this case, and it's something that we have to consider as athletic departments as a whole, sometimes we have unique issues with students when the student athlete is a different gender from the coach. In this case, a little bit of an odd scenario where we have a female head coach that's married to a male assistant coach coaching a female player. But a lot of times we see this in women's sports that have a male head coach or might have multiple male assistant coaches coaching an entirely female team. Third thing that we run into in this case is, if the coach themselves is the wrongdoer, knowledge of that is not imputed on the school for Title IX purposes. And I emphasize that and state it again because that is for Title IX purposes. It's not a complete foreclosure of liability that the school might have for misconduct committed by a coach. And the last thing that we want to look at here is that one of the things that helped the university itself avoid liability is that they offered the plaintiff multiple meetings and opportunities to discuss any issues that they were having with the coach. We didn't cover it completely during the actual background, but ultimately the school offered the plaintiff no less than 4 or 5 meetings, all of which the plaintiff only addressed allegations of communication issues or general concerns they were having between the coach and the player in terms of playing time, things like that, not the specific allegation of misconduct. And this is important because one thing we want to do whenever we're dealing with these student athletes, because of the multitude of concerns that might cause them not to report things, is just be there to offer multiple meetings and be open before, kind of unpacking everything that we need to unpack in terms of what those allegations are and what we're being told and what we're not being told. So moving on, we have one more case that I want to talk about. Is Kesterson versus Kent State University. In this case, we had a female athlete who reported to her that the coach's son, a male athlete at the university, had sexually assaulted her. Allegedly, the coach tried to keep the situation between themselves, reporting the incident. Ultimately, the player alleges that she began to experience some negative consequences. The plaintiff later told other university officials about the assault, but no other person directly reported the incident to the Title IX office. The plaintiff ultimately contacted the Title IX office herself and reported the assault, as well as the coach's failure to report. And you guessed it, she ultimately filed a lawsuit. The plaintiff sued for violations of her constitutional rights and for Title IX violations, but the court found, in terms of individual liability, that clearly established law maintained that a coach could not retaliate against a player for reporting sexual misconduct. I think that's pretty well known and pretty apparent to all of us, but that's one of the concerns athletes have. And in some cases, it's somewhat valid. The court also found that the plaintiff's coach and other university personnel should have reported the allegations to the university's Title IX office, and that they were also mandatory reporters under the institution's internal policies. However, none of the university officials that they had received the reports were appropriate persons that could take action to investigate or remedy the reports necessary to invoke Title IX liability. Also, failure to follow that institutional reporting policy did not amount to deliberate indifference for the purposes of Title IX liability. And again, this case gives us a couple important takeaways to kind of hit on some of those unique factors that we saw earlier. We have a situation where a coach is wanting to handle things internally rather than make a larger deal about them or report through official university channels. We also have a situation where a coach, in this case for perhaps more personal reasons than programmatic reasons, wants to keep the situation under wraps and deal with things in-house, is the term we typically hear used in that kind of situation. And then finally, the other takeaway we have in this case is the importance of mandatory reporting. And that's something important to get across to athletic department personnel, not just coaches, but coaches, assistant coaches, trainers, anybody really that's involved with our athletics, that there are these mandatory reporting requirements, and they're vital to the university's operations and result in consequences. In this case, even though liability didn't follow, the university ultimately dismissed the coach who failed to report and had some punishments for the employees under her that failed to report as well. So we've talked a lot about the problems here. Now I want to talk about a couple of the best practices that we can use to get around some of these issues. As Alex mentioned earlier, one of the most important issues here is maintaining confidentiality. And that's important for a number of reasons, because it alleviates some of these concerns with honesty, completeness, truthfulness in investigations when the players understand that this is not necessarily a public matter, but something that's going to be handled with care and somewhat discreetly by the university itself and the investigators. The second big thing we have to think about here is the anti-retaliation policies. And again, explaining those to all the involved parties, whether they're the complainant, respondent, or witness, is important to the investigation, because it creates a level of trust and confidence between the athlete or the coach with the investigators that this is going to be helped with in a respectful manner that's not going to lead to some of those concerns they might otherwise have. Third best practice we want to think about here is reinforcing reporting obligations to all athletic staff and coaches. And specifically, one part of it is encouraging this mandatory report so the university can handle things in the appropriate method, but the other thing is discouraging handling things in-house. Sometimes we have coaches that want to discipline their players their own way or want to go through that process, but that can lead to a lot of different issues, many of which can result in legal liability for the university. Fourth thing, especially when we're meeting with our athletes, is to be thorough and exhaust the scope of what's being said. We think back to that DeSecco case. And one of the issues, or potential issues there, is the plaintiff never reported the specific allegations. Well, she reported some concerns, but never got into that specific incident. We like to see, when we're dealing with the student athletes, fully exhausting the scope of their complaints, unpacking everything, asking, is there anything else? Are there any other things that you want to talk to me about? I'm here to talk about anything that might be upsetting you, to try to make sure we give every opportunity for that athlete to be heard. Finally, be aware of the concerns regarding balanced power. Again, these players have their lives in a lot of ways controlled by the coach, especially while they're in these formative years of their life. So when there's an incident involving a coach, the athlete's going to be a little bit worried about that. So we need to be sensitive when we're thinking about those things, and that's going to help us, really get to where we need to be with these investigations when coaches are involved with student athletes. So with that, I'm going to turn it over to Jason here, and I apologize, Jason. I've probably gone a little bit longer than I intended to, but I imagine Jason's got some pretty informative stuff for you guys to share that you all came for. So, Jason?
Thanks, AJ. No, I appreciate it, and AJ has assured me he's never been under an NCAA investigation, but it's a big rule book, and I'm sure you may have inadvertently broken a rule there sometime during your time at Appalachian State. In any event, what I want to talk about, and I'll be efficient with your time, is NCAA investigations. And when I talk about NCAA investigations, what I'm really talking about is any investigation either initiated by the institution or requested or initiated by the NCAA that involves a potential violation of an NCAA bylaw. What we'll talk about today, really are the types of inquiries that could involve student athletes, and give a little NCAA 101. Requirements pursuant to NCAA rules, the NCAA interview notice form and what that entails, some case precedent, what is limited immunity and how does that apply to student athletes, and then some other consideration. So getting right into types of NCAA inquiries, what we're really talking about here is whether something is a major violation or a level 1 or level 2 in Division I, meaning it needs to be adjudicated by the Division's Committee on Infractions, or in Division I, the Independent Accountability Resolution Process, or whether it's secondary or level 3 in Division I. So in Division I, there are levels of violations. In Division II and III, there are only 2 categories, a major violation or a secondary. And really, level 3 or a secondary violation is any situation that's isolated or inadvertent, provides or was intended to provide a minimal recruiting, competitive, or other advantage, and does not include any sort of significant impermissible benefit. So, think of, minor recruiting violations, inadvertent violations involving student athletes, not situations that involve extra benefits, academic improprieties or the like, or something that results in an inducement for a prospect to attend your institution. And we're also, we want to keep in mind there are institutional inquiries and there are NCAA inquiries. And it's very common that your institution will have to report level 3 or secondary violations. And that's something that your athletics department handles on a regular basis. And also, certainly it involves a level of investigation. But anytime that there is a potential for a major violation or a level 2 or level 1 violation, that is something that the investigator needs to be aware of. Certainly, general counsel should be made aware of, and that way the institution can handle it with the appropriate sensitivity if it is, in fact, an institutional-led investigation. With respect to formal NCAA investigations, before the NCAA enforcement staff can initiate an investigation into a student athlete or any matter on your campus, they have to issue what's called a notice of inquiry to the institution. They do that either in written form or verbally, and essentially it sets forth your requirements as an institution and what you need to do. It also would involve informing the institution of whether there are involved individuals or fact witnesses that are student athletes. Involved individuals means, under the NCAA parlance, that there are current or former student athletes that have significant involvement in allegations of violations. And really the important point here is that it's really something that can affect a student athlete's eligibility. oftentimes student athletes will be fact witnesses, so to speak, in potential violations involving coaches or other individuals that pertain to situations, whether it be another student athlete situation involving benefits, for example, or perhaps a practice or competition related violation that is being investigated. One thing that's important for everyone to know is that the NCAA can interview former student athletes without your knowledge. So if they transfer to another institution, they are required under the NCAA cooperative principle to submit to an investigation and an interview, otherwise have their eligibility jeopardized. And that's important. That's an important point for your current student athletes. There's not a situation where a student athlete can refuse to participate in an investigation and maintain their eligibility at your institution. Essentially, their cooperation is expected and required under NCAA rules. So that leads us to what are the specific requirements. And in all three divisions, there is a bylaw 10.1, that talks about what is unethical conduct. And it applies to prospects and enrolled student athletes. And it basically requires those student athletes to submit to interviews with either the NCAA or the institution related to matters of a potential NCAA violation. And if they refuse to do so, they have committed what's known as unethical conduct, which again affects their eligibility. If they knowingly furnish misleading information, they have committed unethical conduct, which affects their liability. And also if they compete under an assumed name or fail to complete accurate information that's provided to the NCAA to deem whether they're amateurs or not, again, that would result in unethical conduct. In addition to the standard 10.1 language, there's also other prohibited activities in Bylaw 10, and most significantly, that includes a prohibition for student athletes against sports wagering. That means that student athletes, with respect to any championship that's sponsored by the NCAA, they can't engage in any wagering activities. So, for example, they cannot engage in any NFL or NBA wagering activities, otherwise they're subject to a violation. However, for example, they could engage in betting on a horse race, because that's not, it doesn't involve a sport that has a championship sponsored by the NCAA. It's an interesting distinction, but an important one. And as I mentioned, violation of Bylaw 10 can significantly affect a student athlete's eligibility. Oftentimes it can be a situation where a student athlete is presumed to have lost a year of eligibility and has to sit an entire year before they're eligible again to participate, up to the potential for permanent ineligibility if they violate an ethical conduct provision. It's important to know that the NCAA has different divisions, and enforcement is separate from what's called student athlete reinstatement, which is the group that you would go to if an athlete violates a bylaw and needs to have his eligibility reinstated, either as a result of a Bylaw 10 violation or an underlying violation. And so it's a separate process, but it's managed at another department in the NCAA, not under the purview of the enforcement staff. And what's important here is that this group has specific guidelines that articulates what the presumptive penalty is for particular violations, including the amount of time a student athlete would have to sit if they receive an extra benefit up to certain amounts of money, and what the presumed penalty is if they, for example, fail to provide truthful information in the course of an NCAA investigation. There's also, I'll mention, the opportunity for the athlete to appeal directly any decision of the student athlete reinstatement committee to a committee of member individuals from the NCAA membership that would ultimately decide in a final format what that individual's eligibility penalty would be. Moving on quickly to the NCAA interview notice form. All three divisions have what's called an NCAA interview notice form. And so if the NCAA is coming to interview one of your student athletes, that's a form they have to provide to the student athletes. And the first thing that it says is that you're going to be interviewed and you have a right to be represented by personal legal counsel during the interview. And so the NCAA does permit institutions to pay for counsel for individual student athletes in situations where they deem appropriate that affects their eligibility. Student athletes obviously on their own accord can at any time obtain their own personal legal counsel to assist them through an NCAA process. In addition to that general statement, there's a few specific items in the interview notice form to be aware of. First, the NCAA is required to disclose the purpose of a particular interview. And what they'll say is the purpose of this interview is to determine your knowledge of or involvement in a violation of NCAA rules. So not very specific. Oftentimes, however, the NCAA will advise you as to whether the student athlete in a particular situation, whether that individual's eligibility is at risk. And that would be a trigger to discuss with that individual student athlete whether they should seek their own personal legal counsel or whether the institution in this particular situation would be willing to provide counsel to the student athlete. There's also a responsibility to cooperate, and we talked about that earlier. One thing to realize is that responsibility doesn't just extend to the interview itself, but extends beyond that to the responsibility to produce information to the NCAA upon request. So, for example, oftentimes the NCAA enforcement staff may request cell phone records or other records that the student athlete would be required to obtain on their own accord or use their best ability to obtain and produce to the NCAA. With regard to two other provisions that are in Division I, a failure to cooperate and a failure or refusal to produce materials, the important point here is there are additional, additional penalties that can be associated with these two items in Division I. With respect to a failure to cooperate, there can be additional aggravating factors related to the violation. With respect to a failure or refusal to produce materials, in that situation, that failure can be deemed to be an admission of guilt in that particular situation. So a very important point for those in Division I. And then the interview notice form simply reiterates Bylaw 10 in each division, what the requirements are under Bylaw 10. Quickly going through case precedent, this case here that's identified is from 2009. I pulled it because it's a unique situation where the NCAA felt it was appropriate to publicize a specific outcome in a Division I Committee on Infractions student-athlete reinstatement case. And this case essentially involved, as you see, Des Bryant. What's important for everyone to know is that when the NCAA takes in one of these cases, when they require an institution to request reinstatement, they provide or require a student athlete to execute a FERPA release, which gives them the ability, based on their own determination, to release information related to a case in response to inquiries that it receives, from the media. And so in this case, this was a high-profile football athlete that was withheld from competition, and the NCAA publicly released their determination, which was that Des Bryant was required to sit out a year and charge the season of competition based on his particular violation. The reason that this violation is, I think, significant here in this conversation is because it was really not an underlying violation that resulted in his ineligibility. It was the fact that he provided what was deemed to be false and misleading information to investigators about what he had done with respect to former professional athlete Deion Sanders and meeting with Sanders at his home and with an agent. But it's important to note there was not any finding that there was an underlying agent violation related to his conduct. And so his penalty, very significant, was really the result of his failure to provide truthful information. It's been used, moving forward as evidence of how seriously the NCAA enforcement staff takes that provision and how important it is for student athletes who are in situations with the enforcement staff to provide clear information, and you know, in those situations have appropriate counsel about what the expectations are and ultimately what the penalties could be for their playing career. I've also identified James Wiseman case from University of Memphis. Wiseman was a high-profile men's basketball athlete. And what I wanted to emphasize here is that Wiseman, on his own accord, had personal legal counsel and filed a temporary restraining order, was granted in district court there in Tennessee. And ultimately, it was to prevent the NCAA from implementing what they believed to be an appropriate suspension for violations that they had identified in his situation. Separate and apart from what the violations were, the important point for you as institutional representatives to understand is that the NCAA separately has a bylaw that requires institutions that are obligated to withhold ineligible student athletes. So in this situation, even though they were under a court order to play Wiseman, they were going to, as an institution, still be held accountable for playing that young man during that time period, and the result would be a vacation of contests and additional potential penalties through the NCAA infractions process. So, you know, the NCAA has taken great steps to eliminate the ability for student athletes to independently get favorable decisions from local courts related to their individual application of private associations rules. Now, I say that now, but you know, things are changing rapidly, and this could not, you know, may not be the case in the future. One other point here with respect to precedent. There is precedent in an NCAA system called RSRO, which is accessible by all institutions through their athletics department. The student athletes' names and institutions are redacted from that precedent, but you can search for particular situations to determine what the penalty for a student athlete would be from an eligibility standpoint. It's important to note that not everything is in that system. The NCAA has discretion to archive specific cases, and those cases are only basically a five-year snapshot period, and so they're archived after every fifth year. So there's 5 years worth of material that you can access as an institution. Quickly going through NCAA limited immunity. This is very important. If you're in a situation where a student athlete is transferred to your institution, he or she is requested by the NCAA enforcement staff to conduct an interview. It's important to ask whether that individual is at risk for a violation and whether there is any opportunity for immunity. The NCAA has regularly granted immunity through the NCAA Committee on Infractions to student athletes, which basically means that they're not going to be held accountable for any potential eligibility issue for a violation that they were involved in. It's limited in as much as it doesn't prohibit an institution from taking individual action against a student athlete, and it does not alleviate a student athlete of any future violations that might occur. Only the violations that occurred either at their current institution or at a previous institution. Again, it's most often used when there's a transfer student athlete and the NCAA is aware of a significant issue that occurred and understands that the student athlete in that particular situation should not be fully culpable for the actions of an adult coach, for example. Finally, real quickly, other considerations for the institution. There's a 4-year statute of limitations. Most student athlete issues will fit within that 4 years, but we're in a time period where there is extended eligibility as a result of COVID and other factors. So it's important to understand that there are limitations on the authority of the NCAA to bring allegations related to violations. With respect to academic violations, those used to be included in Bylaw 10 as ethical conduct, and now they're in Bylaw 14. What's really important for everyone to know is at all three divisions, the basic rule is to follow your institutional policy for all students with respect to academics. And so if there's the involvement of others in a scheme to assist in obtaining a particular grade that results in an erroneous declaration of eligibility, then that could also be an NCAA issue in addition to an institutional issue. However, the typical student-to-student conduct issues that may arise from time to time are not separately all the time an NCAA violation. And one final thought, I know we're 10 minutes over here, but with respect to your own 10.1 statement, you may consider as an institution a couple of things. One, if there are crossover investigations that could involve NCAA violations, but also involve other issues, whether it's conduct issues of coaches or Title IX, you may consider whether you want to have a separate investigation, or you want to include a 10.1 statement in the investigation you're conducting, meaning that the institution would separately advise the student athlete of his requirement to provide truthful and complete information about potential NCAA violations or face potential issues with that individual's eligibility. I have seen that used at different institutions from time to time to assist institutions in understanding the significance of a particular issue, whether it be strictly an NCAA matter or whether it's a quasi-NCAA matter. In other words, there are other components of it that might be outside the scope of NCAA rules. So that's a tool that you may consider using. And then finally, anytime there's an institutional investigation that could be a potential NCAA violation that rises to level 2 or major, you're going to want to determine whether you're going to conduct that investigation consistent with the manner in which the NCAA would conduct it, or whether you're going to immediately contact the NCAA. And the reason I bring this up is because you don't want to engage in duplicative efforts as an institution. If you conduct an investigation consistent with NCAA protocols, it's more likely that the NCAA will at least accept initially a final report of that. However, if the investigation is not conducted consistent with NCAA protocols, and that means the provision of a 10.1 guidance to all individuals investigated and potentially recording the interviews, then it's less likely that the NCAA is going to accept a final investigation of that and will require their own review and potential reinvestigation of the matter. So with that, I apologize that we went over. I thank you for your time. Hopefully there was some good information you got from this, and we're obviously always happy to answer any questions that you have and follow up on any of these issues.
This concludes our webinar. Thank you.